and welcome everybody to the PIDE webinar on Understanding Workplace Harassment. I'm honored to have two very renowned speakers with us here today. Before I go on to introduce the speakers, I'd like to briefly discuss the context and scope of today's conversation. In this whole series on understanding workplace harassment, we will cover the topic of workplace harassment from several aspects, including but not limited to an overview of what constitutes as harassment, how prevalent it is in organizations all across the world and particularly in Pakistan, understanding the impact, how it impacts the social and economic lives of those affected by it, prevention and policies, organizational policies, legal procedures, reporting and support, training and education, and accountability and consequences. So with that having been said, I am glad to welcome and introduce both of our speakers. Our first speaker today is Barrister Nausheen Ahmed. Nausheen Ahmed is a barrister at law with over 30 years of law firm and in-house counsel experience in various sectors, including oil and gas, FMCG, banking, and large-scale manufacturing. She has served as company secretary and legal counsel in ICI Pakistan and HBL. Nausheen Ahmed serves on the board of Mizan Bank Limited, which is currently the largest Islamic bank in Pakistan, International Steel Limited, Jubilee General Insurance. She teaches director certification programs at IBA and the Pakistan Institute of Corporate Governance, and is visiting faculty at the Institute of Business Management and the Karachi School of Business and Leadership. Nausheen Ahmed is a master trainer and a mediator who qualified from CEDR UK. She is a founder of the IBA Dispute Resolution Forum. Welcome aboard, ma'am. Our second speaker is Ms. Khawar Mumtaz, who's a Pakistani women's rights activist, author, and a university lecturer. She's the former chairperson of the National Commission on the Status of Women, who served for 2 consecutive terms from 2013 to 19. An active member of the women's rights movement, she worked with the leading women's rights organization Shirkat Gah, where she became its CEO. In 1981, she was a founding member of the Women's Action Forum and has been associated with the women's movement in Pakistan ever since. Mumtaz's research, writing, and lecturing have focused on women and development, feminism, politics, the economic and environmental challenges facing women, and sexual and reproductive health. In 1989, she received the Prime Minister's Award for the co-authored book, Women of Pakistan, 2 Steps Forward, 1 Step Back, recipient of the Civil Award Sitare Imtiaz for promoting women's rights. Mumtaz has a Master of Arts in International Relations and a diploma in French. Currently, she works as an independent consultant and serves on several boards. Thank you so much for joining us, ma'am. We will begin with the first speaker, Ms. Nausheen Ahmed. Ma'am, we would each speaker would have around 15 to 20 minutes for their initial talk, and then maybe we can have a discussion and carry forward with the questions.
Okay, so Mariam had asked me to introduce all of you to this law, and I will start with a little bit of history. That this law, which is now I would say in retrospect that it's a little misnamed. It was the law for the protection of women in the workplace. And the first time it was introduced was in 2010. And the government at that time did extensive lobbying as well as consultation with businesses and with interest groups like the Pakistan Business Council, the Overseas Investors Chamber of Commerce, the Federation of Chamber and Commerce. So in a way, when this law came out in 2010, it had already been looked at by a number of stakeholders, and there was a degree of ownership and acceptance of its contents. But that degree of ownership and acceptance of its contents really came from the larger companies in the formal sector. Now, the law was rolled out at that point, and I'll come to the definition of harassment in a moment. But essentially, what the law required was that it applied to all companies. And even at that stage, it applied to universities and educational establishments, to hospitals. And essentially, what the onus was on the employer. And the onus was on the employer to make sure that the code which was attached to the law, that code was placed in prominent positions all over the organization, in Urdu and in English, and that an inquiry committee of 3 persons was notified, and one of those persons had to be a woman. And if you were in an organization where you had a large workforce, which was a non-management staff, so covered by the labor laws, then your CBA representative could also be a member of this committee. So the organization was required to place this code in prominent places. It was required to notify this committee and designate a method whereby complaints could be made to the organization. Now, as the law got implemented, and as especially civil society and women's groups and a group that Khawar and myself, we are fairly deeply associated with, Shirkat Ka, they've also contributed a lot to the newer amendments in the law. So what we found was that it was a good first step, but it needed some updation and strengthening. So in 2021/2022, an amendment to this law was promulgated, and there were a few significant changes that were made. One of them was that this law was made gender neutral. So harassment with a sexual connotation could be of a transgender person, and it could be of a man as well. The second thing that it did was that it took away harassment within a workplace, and it in a way broadened and expanded the definition of a workplace to include people who are working from home for a particular employer, the gig economy, media, people who were making films or were in advertising. And it also said that you may have been employed by a particular establishment, but if for any reason you have left the establishment, even as an ex-employee, you could file a complaint for harassment. Now, the other significant change that came in 2020-21 is, 21-22 is that a new definition was added of sexist harassment. And before I go any further, I'll just quickly explain to you these definitions. And harassment is defined by as any unwelcome sexual advance, request for sexual favors, or other verbal or written communication or physical conduct of a sexual nature, or sexually demeaning attitudes causing interference with work performance or creating an intimidating, hostile, or offensive work environment, or the attempt to punish the complainant for refusal to comply to such a request, or is made a condition of employment. So, to summarize, What is harassment? It's an unwelcome sexual advance, which could be verbal, written through social media. It could be the requirement of a sexual favor. It could be linked to giving you a promotion. It could be abuse of authority. It could be retaliation because you're refusing to grant that sexual favor. So that, and now with the new amendments, it includes cyberbullying or talking about somebody on social media. Okay. It could be a sexually demeaning attitude or even remarks. She's a loose woman. And people within the workplace not talking to her. So that is sexual harassment. And the law in 2020, the Supreme Court also issued a judgment. And in that judgment, unfortunately, they defined sexual harassment under this particular law in very narrow terms. They said any type of harassment cannot be covered under this law. It has to be harassment which has sexual connotations. Mariam mentioned that I worked for a number of organizations. I also do quite a bit of training on this law. And what you find is that a lot of organizations, there is a general harassment that people face. Now, what we have to understand is that if it's a male-female thing, but you're not asking for sexual favors, but you're just a bully, and you bully everybody in the organization, it's abuse of authority. It may not strictly come within the ambit of the law. So when we are proceeding under this law, we have to make sure that we look at this definition and we bring our case very much within this definition. Now, what most organizations have done is that in their code of conduct, they also have a general prohibition against all forms of harassment, even male to male. Shouting, screaming, bullying, keeping people working long hours unnecessarily, spoiling people's appraisals. And that they classify as misconduct. So a lot of organizations cover both aspects. But if you're going to bring your case under the 2010 law, then remember the Supreme Court case and remember that it has to be linked to sexual. Now, to make things in a way more complex, this new definition of sexist harassment was promulgated in 2021. And sexist harassment is institutional discrimination. It is when you are not provided opportunities because you are female. Or if you're working in an education establishment, for example, where they favor women and you're the sole male person, you are not provided those opportunities because they're not really interested in having male teachers in their establishment, and you're there as a stopgap arrangement. So maybe you're deprived of promotions, maybe you're deprived of training opportunities, maybe you're deprived of exposure in the field, which is important if you're working for a manufacturing company which says if you don't have sales experience, you can't be promoted. Or you're an engineer and you're only supposed to work in the head office and you're not allowed to work in the factory. And that means that eventually you'll hit this glass ceiling. Now, if these are matters which are of an institutional nature, then they fall within this definition of sexist harassment. Mariam, I think I'll stop here, and then maybe later we can talk about the enforcement mechanisms.
Yes, ma'am. Thank you so much. Thank you so much for a very brief and a very crisp introduction to the law and to the way we define harassment in the workplace. I will now move to our second speaker, Ms. Khawar Mumtaz, who will talk to us about the implementation issues of the law. Thank you so much, ma'am, for joining us here today. I'm handing the floor over to you.
Thank you, Mariam, and thank you, PIDE, for arranging this this webinar, because I think harassment and the law is not always fully understood, nor and its application and implementation have had quite a few problems. I've been engaged or connected with the problems of implementation of the law when under the 2010 version of it, and now more recently of the 2021 version of it, after the amendments. I mean, there've been something positive, a few positive amendments by expanding the scope of those who can be who can be covered by this, is the inclusion of transgenders and not making it only on women and gender also, as Nausheen very well explained. The sexist behavior can be, or sexist harassment can be against men also. But there are other, there are a few things that are a bit unclear, and the scope of people who come under it, somehow without any details of how to deal with those. For instance, home-based workers, or for instance, the transport workers. There is also overlapping jurisdiction. For instance, domestic workers. There's already in Punjab there's a domestic workers law which deals with domestic workers issues, and I believe it's at the federal level also there's been work being done on it. So and similarly, cybercrime and harassment online harassment falls under the PICA 2016 law. So there are these overlapping jurisdictions, and there are also the complications of online and offline harassment. So those are the complications which I won't go into in detail. But what I have found, 2 or 3 things. For instance, the law requires a very prominent display of the code of conduct, and we find that is not displayed, and a lot of people are unaware of the fact that there is a code of conduct that every institution, private and public, has to follow and comply with. The other issue is, of course, of the harassment committees that are prescribed in the law, and we find that those also are not always present in those institutions. The issue also is the composition of the committees. There have been actual cases that I've had to deal with, for instance, where within an institution, the social relationships of the members of that committee and the complainant often come in the way. If it's a complaint against a senior person, and the committee is composed of juniors, there is a reluctance to apply the law. So there are a number of issues of implementation that need to be somehow factored in, and probably have to be factored in through development of SOPs. There are standardized procedures have to be needed much more, and also awareness of the law within the institution among the management as well as the employees. I think there's a lack of understanding of the law, and also, as Nausheen also referred to, is what actually constitutes harassment and how do you remain within the ambit of the law. I think there's a general sort of perception of harassment, and for instance, that there is confusion. If you remember, there was a High Court judgment, Lahore High Court judgment, where Justice Jawadul Hasan said that harassment should be considered harassment even when not considered harassment by another person. So there is a level of confusion there. On the other hand, Justice Milanda had said that mere administrative action could not be treated on a par with sexual harassment. So there are confusing judgments and interpretations, which I think create problems. I had the opportunity of looking at the Higher Education Commission's harassment. They have a harassment policy, but you find that the lack of seriousness with which such an issue is taken, there was no dedicated person to look after after that committee, no documentation of cases that come, no details. So I think all those things come in the way of implementation. And secondly, the whole issue of how do you provide evidence, because harassment can be in a situation where there is no third party present. Harassment can not always be recorded or documented. And I think that creates the other problem, how it's one person's word against the other. Very difficult, unless many cases nowadays have been the communication through the mobile phone, which then becomes a very important evidence. But otherwise, it's very difficult to have evidence. And I think we need some sort of guidance or checklist on what are the kinds of evidence that you can do, because the law as amended calls for documented audio or video documentation as evidence. And the other important thing, the fact that it is quite widespread, or at least women feel that it's very widespread. I'll give you an example. There was this large meeting of corporate sector employees in Karachi, where talking about about interventions for improving women's participation, safety, security, opportunity. And then from the podium, it was asked how many people think that there is harassment. 3/4 of that assembly put up their hands, women. So the point is that it is something that's very widespread, and it is something that needs to be implemented. But one aspect that we've had many consultations that Nausheen has referred to. Even at the National Commission, I was assigned to look into this and see where the amendments have to be. And we discussed the challenges to complainants, the challenges of providing evidence, the kind of issues that emerge from the committees that are formed. But we somehow never have discussed in depth the misuse of the law, because there is also the misuse of the law. And often the misuse is not directly related to sexual harassment. It's other kinds of opportunities, promotions, or one not sure, but a lot of misuse also happens. So I think we need to also maybe discuss here with so many people present that what can be done with that. Maybe Nausheen as a lawyer can help us with that. And finally, the procedures and the process of going to the ombudsman. I think people need to be within institutions. It's extremely important for people to know how to proceed in a case of harassment. What is a complaint, and how does the ombudsman, the procedures there at that time? The office there has to find a solution within 3 months. But often we see that cases go on and on for months. So one needs to know exactly what is expected and how important every evidence is, and how to go with the flow of that process also. And not because it takes its own time. There will be many appearances for people to go and explain. And evidence to the contrary is required from those who are challenging false allegations and complaints. So I think it's a very good positive step. I think it's very important. The objective was, when it was introduced, was also that Pakistan has a very low rate of female participation in the labor force, formal labor force. And one of the reasons is the lack of security. And it is to address that lack of security, to encourage women to come and participate in the work areas, whether it's businesses or anything else. So this was a very important step, and it went through a whole range of consultations, as mentioned earlier. And there was, and actually the National Commission had a harassment implementation committee was formed, and Fawzia Saeed was in fact in charge of making sure that public sector institutions were actually complying as much as possible. But this has to be internalized by institutions, because it is an extremely important aspect of women's participation. So I think it would be good if people could have some questions, then we can lead on from here. Unless there's something, I'll come in again if you have further questions.
Sure, ma'am. There are some questions. I think it's best we discuss those questions and then open the floor for questions.
Sure.
So, Mariam, could I add to what Khawar is saying?
Sure, please.
So, I think she's very rightly pinpointed the issues. And essentially, so we created this law for the protection of women, right? And the law says that if you are a complainant, everything has to be kept confidential, and that steps have to be taken so that you're protected from, the aggressor, etc. But what the law says is that you have to be an individual complainant. And one of the points that in different organizations women have raised, and I think it's a very important point, and even I would like Khawar to comment on this, is that if the law is there for my protection, if you want a certain culture within your organization where people are treated with dignity and respect, etc., once I make the complaint, then the organization has to be more proactive about taking that complaint forward and protecting me. So whether it is to appoint the investigation officer, whether it is preparing the case and presenting it before the inquiry committee, whether it is, so I think that, and that's a sort of philosophic or a conceptual switch, that this should not be treated as a private offense. This is an offense where the organization should take a stand against the aggressor. So that's one. The second is that your normal laws of evidence say that people are to be subjected to cross-examination. Okay. Now, the law itself says that you shouldn't, or it's a little ambiguous, but the way I read it is that you shouldn't be cross-examining the complainant. But you can cross-examine the witnesses of the complainant. Okay. And I have spoken to a few senior lawyers, labor lawyers, who insist that an examination in chief cannot be complete until you don't cross-examine. Okay, and then at some point, this issue is going to come up. So again, you're putting your complainant in a situation where your complainant is not really protected. So basically, even though in a way, and then of course there are all the sort of the subtle issues in terms of our social construct, etc., that Khawar was speaking about, which again militate against women, working women, women who are not within the char diwari, etc. So there is a lot of space where this law has to become much clearer. And also, again, the Ombudsman's office, firstly, most organizations do not inform the complainant that the complainant has a right to go to the Ombudsman. Right? If you have to actually read the law, get somebody to read the law to tell you that. Again, when you go to the Ombudsman office, the response is not the way that it should be. and you get disheartened. Appeal is possible. Appeal is possible to the ombudsman, and appeal is possible internally also. And then there is this whole issue, and the law does protect the complainant, where people talk about mala fide complaints. Now, the law says that if you feel that a complaint is mala fide, the maximum that you can do is that you can refer this matter to the ombudsman to take it up, but you cannot take action against the complainant. And I think that that's a good thing, that's a positive thing, but that is something which in many organizations where I have framed the policy, people have argued against it. So the idea is, yes, the law is there, it has flaws in it, as pointed out by Khawar, and one of the biggest issues is finding the evidence. Is finding the evidence to be able to deal with this matter. And then, of course, there is the larger issue where your organization itself is not supportive. And I believe that this is something which is becoming really imperative, because 50% of your women who are coming out of business school, of your class that is coming out of business schools, they're women, and they have to go into the workforce. And they have to get this protection. And if organizations are going to be hiring people on merit, then they have to make sure that they take the onus of this on. So basically, if two people have a fight, two workers on the shop floor have a fight and they become physical with each other, the management does not say to those two workers, कि आप जाके complaint file करें. They say, under our code of conduct, this is misconduct, and therefore we are going to take action against you. But when it's a case of sexual harassment, the management says, yes, you have the right, but you have to file the complaint. So that's the difference. I will not allow my workers to fight on the shop floor or hit each other. I will not allow somebody to slap the supervisor. But if somebody is doing something which has a sexual connotation, I'll say, okay, if you want me to do something about it, then you have to write the report. You have to write the complaint and give it to me.
Right, ma'am.
So maybe Khawar would like to add to what I'm saying.
Yes, Nausheen, I think the very important is the responsibility of the institution. A culture in an institution which is respectful of men and women, I think that's extremely important as a given, because that's where a lot of things can get handled if there is a culture of respect for men and women and for juniors and seniors alike. And I think it's that culture which then enables, if there is a deviation, to deal with it. So that goes without saying. And even when there's a complaint has been lodged, I think it's very important to keep a safe environment without holding anyone responsible till the complaint has been handled, because that also creates tensions. You are actually blamed before anything has happened or a conclusion has reached. But as Nausheen was saying, there are many ways in which an institution can handle it. There are ways in which they can create safer spaces for a person who's being harassed, and restrain a person who is a habitual harasser. There are habitual harassers also. So there are certain things that the institution can take responsibility for. But most important, to instill the code that is expected of all its employees. But as Nausheen was talking about, I've had to deal with a number of cases while I was in the commission, and which I then referred to the Ombudsman's office also. And they're not always straightforward. They're often very complicated. Complicated cases where they're complaining of harassment, and then when the investigation takes place, you discover that it is lack of, the person who's complaining is actually complaining because hasn't worked well enough or is not getting promotion or whatever. So those are the delicate things, that difficult situations that have to be handled with. And usually the ombudsperson's office is the place where it can be handled best, unless your own harassment committee has the trust of all the employees. It's very important if you have a harassment committee, which is either elected by the employees or has the trust. And now under the new law, you need 2 women, I think, but at least 1 woman in that committee. So there are institutions who've handled this very well by making sure that each category of employers feels comfortable with the person who's been placed in that committee, and where they've had actually nominations from the staff. There, the committees work much more efficiently and handle issues. But then there are, as I said earlier, there are both kinds of cases. And as we all know, evidence is the most difficult issue in these cases. And that is where things matter. But also, and we know, is the social context in Pakistan. Is the social context where you get outsiders to lobby for you, for instance. And that creates, it muddies the water. It does not allow for a transparent, clear, clean handling of a case. Because, a harasser will try and marshal all their support in order to get away with it. And even in the case of a false, malafide situations also, that also happens. You bring in lobbyists or advocates from outside to support you. So I think those are things that are at a cultural level, and those culture of safety and institutional transparency of fairness have to be instilled in our institutions. Some of the corporate sector institutions have tried to do that and have actually succeeded in this. But there are many other, even big public sector institutions where it does not happen. And a complainant is actually victimized. So I think these are issues that need to be discussed. But I think very important is for employers and employees to know what their rights are within an institution when they're working, and where are the limits, and what are the internal procedures of complaint. And even if you go to the ombudsperson's office, I think it's very important to know what the procedures are there, and not to go with a blank sort of understanding, because even there are limits. And many of the cases that are taken to an ombudsman's court or complaint arena, they are actually not exactly within the ambit of the law. They're often outside the ambit of the law. So I think all those things are safeguards which an institution should also make sure that people are aware of. And as often, you find that the harassers are too scared to complain. But the responsibility of protection for each worker is the institutions, and to allay anything. The other thing that maybe Nausheen knows, the last I knew, the law is there, it's implemented, but all the rules of business are not in place, nor SOPs. I'm not sure if that has been corrected.
Yeah, no, there are no, Rani, there are no rules of business or SOPs. Mm-hmm. So, in many things, every organization is interpreting things in a slightly different way. And if you're progressive, you're interpreting it in a more progressive way. And if you're not, then, you're just doing the bare minimum. So you're absolutely right there.
So I think there are certain things that we all collectively have to advocate for, is to get the rules of business and SOPs in place. But at the same time, there is an appeals procedure. Because you can go with if you don't agree with the order of the ombudsperson, you can go to the president's office or the governor's office in the provinces. And there are also cases of people going to the High Court and the Supreme Court in appealing the judgments. It takes a long time, but we are not very sure how the law gets interpreted at different levels and at different times also, and how it contributes to improving the understanding of the law.
Ma'am, we spoke about the very muddled nature of the way we conceptualize and understand what constitutes as harassment, including sexual abuse and sexual violence and sexually demeaning comments and workplace bullying and things like gendered behaviors and et cetera, et cetera. I have a couple of questions. The first one is, and either of the esteemed speakers can choose to answer this one. What are some of the best practices that Pakistan can maybe learn from other parts of the world? Keeping in view, of course, the social norms and the cultural differences and the conceptualizations of gender, the social constructions of gender that we kind of import from the society into our organizations, and that kind of reflect in our organizational behaviors when we operate within organizations. So are there any best practices that Pakistan can maybe learn from and maybe they can help us in dealing with the implementation issues?
My take on that is that let us learn from the best practices in Pakistan. I think we need to review some of the cases that have been settled by the Ombudsperson's office to understand what has worked well. And many cases have been resolved there and successfully. And I think we need to also see what the best practice there and what the best practice in the institution is. There's enough body of information there. Actually, I don't have very in-depth knowledge of how things have been done there, but the harassment law does exist in other countries and is applied also. Maybe Nausheen has more information on that. But I do know that there's been good, I've sat in a judgment of the Supreme Court on this issue with a big oil firm in Pakistan. And Asma Jahangir was arguing that case, and it was very positively responded to by the institution itself. So I think there are good examples, and we need to see how those have worked and how the judges have taken those cases. There's been a case of PIA also where there's been a positive judgment. It took some time, but I think those cases and their judgments are important for us to understand what works.
So what I would like to say on this question is that I think Rani already mentioned this respect and dignity. And it's extremely important to have an environment in the organization where people have to respect each other. And it's not, I mean, I've done trainings where, people have said, okay, so sexual harassment, yes, it's an issue. There's a law to back it up. And we don't have that many women in our organization, but if we do, we know that we have to treat them with a great deal of respect, etc. But what about general harassment in the organization? What about organizations where it's acceptable to scream and shout, where it's acceptable to abuse? And an organization like that then becomes a dangerous place for all employees. So I was recently framing a policy for an institution, and I have a friend who works for SOAS, School of Oriental and African Studies, and I said, could you share with me your policy on sexual harassment? And what he shared with me was a 3-page document, which was actually a policy on respect and dignity. And it did have a particular section, but it had a particular section not just on gender, but diversity in general, ethnicity, transgenders, people with different sexual orientations. But that's your best practice, that we have to have organizations that have a strong culture where people respect each other and where there is zero tolerance for any sort of abusive behavior.
Ma'am, one more question. I think we have very briefly touched this aspect as well. The aspect of consequence and what happens after a case, let's say, has been resolved. Either ways, if it was a true case of harassment, for instance, what does the law say about the consequence for the perpetrator? And otherwise, the other way around, what about mala fide cases where the cases are proven to be cases of false accusations? Do we have some cases to highlight maybe What are the consequences of those cases? What are some of the decisions that have been made?
She can give you more details, but the law has provides for minor and major penalties, and those can be a range of it, and it can also end up in dismissal or termination. That's the maximum, and the new law has added to it. So there are those penalties which can be awarded to the person who is crossing that line. So, but the cases that I have seen, in most cases, the person who has been declared as a harasser usually leaves the place or is asked to resign, because there's very little room for a harasser in an institution. So the major penalty is termination, of course. The others, there can be, what I've seen in the Supreme Court case, that the gentleman was due to retire, so he was allowed to retire rather than terminate, so that he could get benefits. So those were compromises between the complainant and the institution. So those kind of things happen, but I think that differs from case to case. But in many instances where I've seen that they have, the person usually has to leave, because there has to be zero tolerance for harassment. But there is the other issue that Nausheen has referred to, is bullying, of creating a hostile environment, which therefore has to be a corrective measure from within the institutions with different kinds of standards and timelines, etc. So there's a range of things. The law provides for two kinds of penalties: the minor and the major penalty. There's somebody's hand up, Anjum Altafs, if you. And what was your other question before we pass on to him?
The other end of this whole situation where the case is, let's say, a false accusation, what are the possible penalties and consequences of a proven false accusation?
So in another instances I've seen where the person whose complaint has been victimized, in the end she's had to leave, although she was just complaining. So you have this misuse of the law based on that, what I referred to earlier as social norms, where a senior is seen to be right and a junior can be suspect. Initially, the girls who had complained were not given any work to do, no responsibility, and finally they just decided to leave, because there was no point in becoming the pariahs in an organization because they had complained. So so it varies from institution to institution, and the kind of power a senior holds, that also makes a difference. So I think a lot of it has to do with power relations, but there are many instances now where things have been resolved, people have punished also, and in very, very significant and not only educational institutions, government institutions, in the Foreign Office itself, for instance. So it does happen. You have the person who's complained should have the support of people who think that the complaint is genuine and authentic. But if it is a malified complaint, then I think there is a different matter altogether. The impact of harassment on a woman, as you know, it makes her insecure, makes her lose confidence, can't give all to her job. So all that adds up negatively for her.
One quick add-on to that question. What does the law say about protecting the complainant? And are there any mechanisms in line for protecting the complainant while the complaint is still in decision, in the process of decision?
Well, I mean, the institution is not to take an action negatively or make it difficult till there's a resolution and solution to it. Whether it happens or not is another question, of course.
So under the law, you're supposed to keep it, as I said, confidential. The second thing is that the person who you have complained against can be sent on leave if the policies in your organization allow it, or there can be certain measures taken so that the complainant and this person, the defendant, do not meet each other. The defendant does not have a chance to pressurize the complainant or the witnesses of the complainant. The complainant has access to medical advice as well as psychiatric help under the law. And the complainant also has the ability to ask the organization to give her somebody who can assist her with the inquiry. So somebody from within the organization who can assist her with the inquiry. So this is all stated in the law. But, you know, whenever I do training, everybody always comes back and says, oh, this confidentiality issue is never adhered to. And that's a severe deterrent. But again, coming back to what Khawar said, you know, your organization has to be serious. They have to believe that they're going to do this. And therefore, if there is a breach of confidentiality, they have to take action against the person. I think Anjum Altaf has been, you know, has had his hand up for a long time.
I'm Samia Altaf. I want to congratulate the panel on this very wonderful discussion on a very difficult topic. However, I think that we need a little bit of a more nuanced discussion on how this implementation. Khawar had raised this issue earlier, that where the rubber meets the road is in implementation. So that we need to see how the implementation actually plays out in real world. And the other thing, the other issue that was raised was, again, I think Khawar raised it, that it's an issue related to the culture of the organization. I'm going to present, if you will permit me, you know, a little bit of 3-4 minutes of the time, I'm going to present to you, to the panel, an actual real life case of sexist harassment, which has been filed against one of the leading academic institutions of the country. I will take that institution's name because the information about this case is now in the public domain. It is LUMS University, Lahore. The case against sexist harassment has been filed by one of the professors who was on a contract job at LUMS during the COVID time. And the response and all those things that the panelists have mentioned in terms of you know, the institution should come forward and they protect the complainant, and then there should be a process which should be completed in 3 months, and you know, all of those things. LUMS University did not follow any of those procedures. When the complainant filed, and this was not sexual harassment, this was sexist harassment. This woman was bullied and harassed by a co-worker, male co-worker, who created, you know, she claims that he created a hostile work environment and did not allow her to do the work. She brought it to the notice of the provost of the institution, who also happened to be a woman at that time. And then the provost completely ignored it. She did not respond to it for 3 or 4 weeks, till this woman upped this complaint to the vice chancellor. The vice chancellor then also ignored it for many weeks, but then they set up a hand-picked committee. So the stonewalling and the delaying tactics were because this woman's contract was going to expire very quickly. And so that is what happened. Her contract expired, and so she was outside of the institution. And as far as LUMS was concerned, this case was over. This woman wrote to the, you know, the management committee and to Babar Ali's office and to all those places. And interestingly enough, there was not a peep out of any of them, not even an acknowledgement that they had received her complaint. So this woman then goes to the ombudsman's office, and she goes to Human Rights Institute, and this has been going on for about 3 years now. She goes to the ombudsman's office and stuff. And interestingly enough, the ombudsman in Islamabad, and it was Kashmala Tariq at that time, she listened to the initial complaint, and she said that yes, her office has the jurisdiction to hear this case. But the LUMS University went and got a stay order that this does not fall into her jurisdiction. And of course, you know, if you see the scenario, this is a one woman alone. She's hiring a private lawyer, And the Lum's University brings all these hotshot lawyers, and this man, who happens to be an employee of the university, because he's a male and he's a permanent employee, this woman is a contract person. So the whole power and the might of the university is standing behind that man. This woman has been going through this case for the past 3 years. This case is now in the civil courts. So I would like very much for the panelists to talk about this issue, that it is very well for us to say that institutions should do this, but how can you make an institution do anything? An institution like LUMS is very, very powerful, and the culture, the institution is functions and lives and performs within the culture of this country, which is a very, very misogynist culture. And it's an institution that has at the top very powerful men, who are tycoons of industry and who are tycoons of the academic world. And their connections and their access to all kinds of old boys clubs is enormous as compared to this woman. How far can this woman go? She has already depleted. She doesn't have a job. She has already depleted, quite a lot of her finances, paying. So, here I am. This is Samya. So she has already depleted a lot of her financial capital, and the case is now in the civil courts. So, my question to the panelists is that in the process of implementation and in the process of setting up regulations and the SOPs, what teeth do you have, or the commission has, or the government has, or whoever has, to make these powerful institutions, respond in a timely fashion? The interesting thing is that eventually, when I pushed them, they set up a committee, which was a committee of hand-picked people who were picked by the provost. That committee itself said that yes, this woman has been harassed, and so there should be, and that's it. There was no consequence for that person. That man was actually promoted because this woman was let go, her contract ended, and they said goodbye, thank you very much for your work. And that man was actually promoted, and he was made, the big czar of all of those things. So where does it all go? And another interesting twist is, because this woman kept pushing, and she went to the ombudsman's office, she went to the case is in civil court, that her husband, and I might as well admit it, this is me. My husband, Anjum Altaf, who happens to be an independent, one of the leading academics and public intellectuals of this country, who had a fellowship, an honorary fellowship at LUMS, his fellowship was not renewed. I had an honorary fellowship at LUMS in my capacity as a public health physician. My fellowship was cancelled, and my husband's fellowship, भाई चले मैं तो कसूरवार हूं सो हूं, तो मुझे तो आप कैंसिल कर दें, मगर वो तो बेचारा एक इंडिपेंडेंट आदमी है जो इसकी अपनी इंडिपेंडेंट स्टैंडिंग है, but his fellowship was also cancelled by LUMS. So here we are. So this is a case of sexist harassment, and a woman who says that, I will speak up and I will push back, and the law allows that. The interpretation of the law, of course, it was very lucky that, in this case, I filed this case in 2021, I think in January 2021. And at that time, this definition had been expanded. And in doing this, I have met a lot of women in that institution and in many other institutions who have been killed and buried. Because how many people can go through, how many women can go through this? उनके अपने घर वाले उनको कहते हैं कि बीबी छोड़ो भाई, ये किस मुसीबत में तुम पड़ गई हो, घर भी खराब है और पैसे भी बर्बाद हो रहे हैं, नौकरी तुम्हारी वैसे गई है. So there is a whole lot that is in the gray area. So thank you very much. I would be very much interested in listening to the comments of the panelists. And thank you for allowing me to speak.
Thank you so much.
Samya, I'm glad you brought this up. I'm informed of this case, and I know of similar cases in other institutions where in the end, the victim is the one who because of the kind of our culture, which is a culture where power prevails and where misogyny is all sort of everywhere. One expects more from such institutions, but I've had cases from the Radio Pakistan, for instance, where two very, very bright anchors had to leave because their complaint was mismanaged. A woman on that committee, scolded them for bringing up this case altogether. So these are the realities, and those are our social cultural realities which we need to change. But in this particular case, I think there should be a little bit more, as you said, nuancing, that there should be within the rules, there should be procedure of making those harassment committees and harassment committees where people should recuse if there's a conflict of interest. Harassment committees that are voted in rather than handpicked. There are certain things that can be managed a little better.
Sure.
And I think that those are the kind of things that can be introduced. And I remember we've discussed this in our various consultations of how do we make institutions more responsible and responsive. Yeah. And we find that it's only where you have very, very concrete, in case of actual harassment and abuse, where there has been evidence in the form of online harassment or messaging that you've had people actually getting punished. Otherwise, everybody gets away with whatever. Yeah. And the poor woman who has complained is the one who suffers. But that is the reality, and I think that's what we need to keep addressing. Yeah. But some of these issues can be perhaps dealt with if we have more stricter provisions within the law and its implementation rules. They could be contained quite a bit.
Yeah, if there are consequences for the institutions, if they haven't done what they were supposed to do, if they were supposed to have a committee set up already and all of those things, and if the institution hasn't done that, then there need to be consequences for the commission. Mujhe, if you will permit me, I will take a little bit of your time again. Somebody asked me, "Bhai, aap kya chahti hain?" People said, "Aapko hum mujhse mila dete hain," and I said, "No, I don't want any of that. I want this case to go through the system in such a fashion, and I would like to see LUMS University. It's a very good university, and it has done a great, outstanding job. But good universities can also do bad things sometimes. So I would like to see LUMS University come forward and say, Acha, oh, so this is where we were deficient. Oh, so this is where we were wrong. Okay, let's try and fix it." I mean, how difficult it is for a university like that to fix the things and to overcome the deficiencies within them. But there is a propensity to circle the wagons around men, because these are men who have been friends for 20 years, they work together. वो हर दफा आके कहते हैं कि हमने तो मुझे 20 साल हो गए, मैं लम्स में काम कर रहा हूँ और फला फला. And then interestingly enough, they bring their wives and their daughters to advocate on their behalf कि ये बहुत अच्छे हैं, ये कभी वो नहीं करते, तो मुझे बहुत हंसी आती है. At the ombudsman's office, when she called me and the person I had complained against, he came with his wife, and his wife with tears in her eyes kind of was there advocating on his behalf. I mean, come on, ye kya bala, So I would really like the LUMS to acknowledge that we have these deficiencies. It doesn't matter what happens to Samia Altaf, because, she will survive. Samia Altaf will survive and go on. Magar, I would like the university to right its wrongs within its system. So agar us cheez mein aap log ko unko koi push kar sakte hain ya law kuch kar sakta hai, to I think that would be very useful.
So, Dr. Samia, I just want to add to what Khawar said. And of course, the story that you tell us is sad, but it's not unique. And unfortunately, if we talk about 5 successes, there are 10 which are not successes, And if you and I and we sit down, we can catalog all of those issues. But I think one of the positive things that Khawar mentioned, and I think that's one of the positive things that we should work towards is actually developing procedures so that we can try and limit as much as possible this opening for people to interpret things in their own way, And those SOPs and procedures don't exist. And it's people like us and you and others who have really seen the practical aspects of the implementation of this law. We need to now take the next step, and we need to, in a way, try and draft those SOPs and procedures. And our ombuds persons, they're in every province, they're at the federal level also. They also have to become stronger, but they also, suffer from a lack of budget and a lack of human resource, etc. So that's one thing I want to say to you. The other thing I want to say to you is that in one particular educational institution that I have interacted with, and I won't name them, but it was the students, through social media and through being conscious and aware and standing up for their rights, that impacted quite greatly on this institution. And that institution did not have the ability to sort of walk away from this situation. They had to address it because at the end of the day, they had to satisfy their student body as well. So the thing is that it is also about raising that consciousness and raising that awareness and thinking of things like the Me Too movement.
Thank you so much, ma'am. We have two more questions. There's Faisal Anwar and there's Maria Khan. Faisal, maybe you could go first. And Mariam, meanwhile, could you please raise your hand? Thank you.
Okay, thank you very much. This is Faisal Anwar. My question is with regard to the requirement of evidence in the cases of sexual harassment. I think somebody said that an audio video type of evidence is also acceptable in the court of law. Isn't that an invasion, into privacy? Because I think, I would have expected that it would be a crime to record somebody's conversation or discussion without his or her consent. That's my first question. The other question is basically just to build up on what Mrs. Samia Altaf said about the incident at a university in Lahore. And she said that the complainant had gone all the way up to the Vice Chancellor and even to Mr. Babar Ali. So is it some sort of legal tactic not to acknowledge a complainant's correspondence? Is that something which is actually advised by the lawyers to such institution that you should not respond or acknowledge to such complaints? And how can that be handled? Thank you very much.
You want to answer? Shall I just give my comments and you can add?
No, please go ahead.
The point is that the complainant, if is not satisfied with the system within the institution, has the right to go to the ombudsperson's office. Now, on the issue of ombudsperson, the federal ombudsperson takes up issues which are at the federal level and federal institutions outside the capital territory. And the other is the provincial ombudsperson. So maybe she should have first gone to the provincial ombudsperson. I'm not sure whether she did go to the ombudsperson's office, or even if the ombudsperson's office was functional, because we have these situations where new appointments are not made in the Punjab. The term of office of the chair of the ombudsperson is only 1 year, and there's always a gap between the person retiring and the new one coming in. So there are those issues that that are because of the way our governance system works. But there are, I think Justice Aisha Malik gave a judgment on this, dividing the jurisdiction. But she did go to the ombudsperson who apparently the federal ombudsperson felt it wasn't a jurisdiction. She could have come to the provincial one, and then she's done that was the only last resort, that is going to the civil courts. But the point is, I think what you're raising, and I think we're all discussing and going around in circles with is how do you penalize or hold accountable the institution? Because the case is an individual against a certain person, and the institution is ignoring it. So I don't know whether there is some way of raising that issue, because the institution should be responsible and held responsible for addressing the case. And then, some of the other measures to ensure there is a trustworthy committee within their institution. So, I mean, this is a challenge. This is one of the issues that we need to address.
So under the law, there is a duty on the institution to have this inquiry committee, and there's a duty on the institution to put up the code. It doesn't go further than that. And I think what Dr. Samia's example is showing is that the law has to go further than that. So that's one comment. The second comment on evidence is that there is a lot of case law on evidence, and any evidence which is illegally acquired can become inadmissible. However, when you're living in, in sort of a world of WhatsApp messaging and voice notes and emails, all of that is admissible if it's coming from the person. And all of that, in many cases, is produced by the complainant to support her case.
But also vice versa. I mean, it works both ways.
It
The
does.
pressure also
It
comes.
does.
But, on the issue of evidence, Faisal raised the issue of privacy. But somebody who's being harassed through a phone or a cell phone is within her rights to save it and to produce it as evidence. It is within her rights. It's not a third party necessarily, documenting or recording. On the other hand, the witnesses can be there, and they are allowed under the law to say that a person, their evidence of what they've seen as harassment. So that is allowed. But there are many instances where there is no human evidence. And that's where you find it very difficult to produce evidence to say somebody is being harassed and how to capture that harassment.
मेरा नाम मारिया है और मैं केपी से बिलोंग करती हूँ. अभी रिसेंट मेरा जो रिसर्च वर्क जा रहा है वो पश्तून विमेन चॉइसेस इन द इंस्टीट्यूशन ऑफ मैरिज है. मैंने अभी जो कन्वर्सेशन सुनी वो तो मेजर सिटीज जो है, और मैं एक पेरिफेरी से हूँ और एक गवर्नमेंट सेक्टर कॉलेज में पढ़ाती भी हूँ एज अ लेक्चरर. तो यहाँ पे सेक्सुअल हेरासमेंट की बातें हुई, बाकी हेरासमेंट जो बड़े बड़े होते, लेकिन यहाँ पे पश्तून सोसाइटी में मैंने जिस हेरासमेंट को नोट किया वो फीमेल को हेरास करती है. और हमारे लिए कॉलेज या यूनिवर्सिटी जो है वो भी एज अ प्राइवेट की तरह है, और उसमें क्योंकि वहाँ पे मेल के लिए अलग सेक्शन बनाए जाते हैं, वो आके उनसे लोग पर्दा करते हैं, टीचरें जो होती है, और ना उधर फीमेल को जाने दिया जाता है. तो मेल हमें उस तरह डायरेक्ट हेरास नहीं करते जिस तरह हमें अपने मैडम और ये बाकी लोग जिस तरह हेरास करते हैं, मेंटली टॉर्चर करते हैं. तो इस हेरासमेंट पे भी बात होनी चाहिए, सिर्फ सेक्सुअल हेरासमेंट जो है उस पे नहीं, क्योंकि जिस तरह वो डेली बेसिस पे हमारी एजेंसी को वो क्रश करते हैं, हम जो चाहते हैं उसके मतलब बहुत ज्यादा इस चीज को मैंने नोट किया कि फीमेल पश्तून सोसाइटी में फीमेल को करती है. वो पब्लिक में हो, पब्लिक में तो ऐसे स्पेसिस हमारे लिए नहीं है, पब्लिक को भी मैं एज अ प्राइवेट लूंगी क्योंकि वहां पे इस तरह कुछ नहीं है. तो इस पे अगर मैडम कुछ कहे कि पेरिफेरी एरियाज में इस तरह की हेरासमेंट होती है, इसके लिए क्या हम कर सकते हैं, इसको मिनिमाइज कैसे कर सकते हैं, और हमारी एजेंसी कैसे हमें मिलेगी.
अगर मैं जल्दी से ये कहूँ मारिया कि मैं शुरू से यही आपको कह रही हूँ कि एसेंशियली तो ये डिग्निटी और रिस्पेक्ट का इशू है. एंड ये लॉ सिर्फ सेक्सुअल हरासमेंट को कवर करता है, बट एक्चुअली इंस्टीट्यूशंस को ऑल सॉर्ट्स ऑफ हरासमेंट को कवर करना चाहिए और उसको ममनू बिहेवियर करार देना चाहिए. सो लॉ आपको वहां मदद, ये वाला लॉ आपको वहां मदद नहीं करेगा, लेकिन वहां कोड ऑफ कॉन्डक्ट होना चाहिए. कोड ऑफ कॉन्डक्ट में हरासमेंट, बुलिंग, साइबर बुलिंग, इन सबको ममनू किया जाए, सो दैट इवन फीमेल टू फीमेल या मेल टू मेल एक वो जो एक जनरल खौफ और हिरास वाला जो माहौल है वो हमें नहीं चाहिए. ठीक है ना. सो हमें साथ साथ इस लॉ पे तो जरूर काम करना है, लेकिन आपने बहुत इम्पोर्टेंट पॉइंट रेज किया है जो मैं समझती हूँ कि बहुत जरूरी है. और आप छोटे शहरों की बात कर रहे हैं, मैं तो आपको बता रही हूँ कि मैंने जब ट्रेनिंग की है बड़े इदारों में भी, तो वहां पे भी लोग ये इशू रेज करते हैं, एक जनरल खौफ और हिरास जो हम करते हैं, क्योंकि हमारे माशरे में एज अ सीनियर, एज अ ओल्डर पर्सन इसको सही समझा जाता है.
I mean, I think we've said it before कि हमारे एक social norms and cultures हैं, और we need to somehow raise the standards within our institution. लेकिन एक भी मैं chat group में एक सवाल पूछ रही हूँ, देख रही हूँ, अली साहब का है, वो कह रहे हैं कि misuse. मैं शुरू में ही जब हम discussion शुरू हुआ था, मैंने कहा था कि the law has no, there's nothing in the law to say कि misuse हो सकता है law, या अगर हो तो क्या करें. And I think misuse hota hai. There have been many instances that one has seen of misuse of law, and there has to be some way of dealing with it. एक question मेरा इसी हवाले से था नौशीन से as a lawyer, कि बात ये है कि आप वो क्या कहते हैं, क्रॉस एग्जामिनेशन कंप्लेनेंट का नहीं कर सकते, लेकिन अगर misuse of law हो रहा है तो can we not have the provision of cross examining the complainant, क्योंकि अगर complainant झूठ के ऊपर कोई complaint करता है तो that cross examination becomes necessary. Otherwise, how do you prove that this is not correct?
Okay, so firstly, what I have to clarify is that cross examination means cross examination by the defendant or his friend or whoever's assisting him. That doesn't mean that as the inquiry committee, you can't ask questions of the complainant in the same way you can ask questions of her witnesses or questions of the defendant and his or her witnesses. So that's one clarification I think I must make. The second is that if the inquiry committee feels that there has been mala fide, and the instances of that, at least in my experience, are not so prevalent because our social norms still militate against women filing cases of sexual harassment. So they're afraid to file these. But if there is such a case, then, and the inquiry committee gets this strong feeling, then of course the first step would be to acquit the accused. The second step would be, and the law says that as the inquiry committee, you cannot take action against the complainant, but you can make a recommendation to the ombudsperson, and the ombudsperson would have to take action. So that's another level of protection that is provided to the complainant.
I don't know, I hope that sort of clarifies something. The question is about Misha Shafi's case. Actually, it was Misha Shafi's case which was one of the evidence for broadening the scope of this law, because she was not in an employer-employee situation when she filed her case against Ali Zafar, and the earlier version of the law only provided for employer-employee situations and workplace. A studio which is rented is not anyone's workplace. So that has been taken care of in the law now. The other thing is that there's another clause in the law which is about retaliation, defamation. Now, Ali Zafar has gone ahead and filed defamation cases against her. So the law at the moment does not allow for retaliation. So I don't know how it's playing out in the court, but I do see that because of her case, there was a lot of debate on the law, and some changes have been brought in because of that. And of course, as Neelam says in the chat box, that there are cases of harassment in the informal sector, and all that sector is now part of the law. But how do you implement the law in the informal sector where people are scattered in various homes and there's a contractor in between, and the person who's actually getting the work done is just at a distance? So those things have not been worked out at all in the law. How will it be implemented in those instances? So those are still, in my view, fairly black holes to say, until we unpack them and see what procedures can be applied there and how.
Thank you so much, ma'am. Thank you to both the speakers and to all of the participants who asked very pertinent questions. This helped us initiate a very powerful discussion about the nature of workplace harassment in Pakistan. We are hoping to further discuss the legal aspects and the implementation aspects and the organizational systems that need further nuance in terms of making it easier to implement the law, and then the law itself, of course, from a legal point of view. We're aiming at making this webinar into a series, and I've taken notes throughout the discussion, and they will help us set the tone for the next webinar. Thank you so much once again to both of the speakers and to all of the participants for being here with us today. I'll sign off now and see you guys soon.
Thank you. Thanks, Mariam.
Bye, Rani.
Bye, Nausheen.